Welcome to the City Council meeting on the 21st of June. It is now 7 o'clock. So Councilmember Brownrigg, please lead us with the Pledge of Allegiance.
I will, Madam Mayor. If you would stand if you can, place your hand on your heart and join me. And I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Thank you, Councilmember Brownrigg. Megan, can we have roll call, please?
Councilmember Beach.
Here.
Councilmember Coulson.
Here.
Councilmember Brownrigg.
Here.
Vice Mayor Ortiz.
Here.
And I am present.
Mayor O'Brien.
Mayor O'Brien. I can't go on vacation. That's what happens. Mayor O'Brien.
I am here. All right, we did not have a closed session, so I will go right into the upcoming events. So we have our outdoor movie night on Friday, June 25th, around 8 o'clock at Washington Park. I think the movie is The Great Outdoors. Then we have our virtual memory cafe Wednesday, the 7th of July, and also the 21st of July at 2 p.m. We have a Storm Drain Citizens Oversight Committee vacancy, so we are accepting applications. They only meet once a year. Just a reminder, the Fresh Market Farmers Market is on Thursdays from 3 to 7, and then on Sundays from 9 to 1. We have the Burlingame Washington Park Craft Market from 10 a.m. to 6 p.m. on June 19th and 20th, July 10th and the 11th, August 14th and 15th. We will have the annual city shredding event on Saturday, June 26th from 9 to noon at parking lot O, located at 290 California Drive. Tonight also, I would like to acknowledge that the Burlingame High School baseball for becoming the 2021 CCS Division III baseball champions. And I know we have something in regards to the basketball team, which I am trying to find. It is 7th time is a charm for Jeff Dowd. In his second stint as head coach of the Burlingame Panthers, the architect of one of the most consistently dominant public school programs in the Bay Area finally earned a section championship on Saturday night as his team downed the previously unbeaten Santa Cruz Cardinals 43-39 in the CCS Division III championship game. No matter how big or small Dowd's teams are, no matter whether they're underclassmen or seniors, defense has been a constant for the Panthers, and it showed up in a big way on Saturday. Second-seeded Burlingame held the Cardinals 22 points lower than their season average, only allowing double-digit points in one quarter. So the Burlingame Panthers have done a great job this past weekend. All right. We will go on to presentations. We have one presentation today. We have a proclamation recognizing June as Immigrant Heritage Month. Whereas Immigrant Heritage Month is a time to remember that nearly all of us can trace our heritage to another nation. And this month is a time to honor and celebrate the many varied contributions of immigrants who came to this country to work hard, seek opportunity or protection, and give a better life to their children. California's strength is in its diversity. The economy, universities, and communities are stronger and more vibrant because of the nearly 11 million immigrants who call California home. About a quarter of all foreign-born people nationwide. And whereas the pandemic underscored the importance of immigrants who worked on the front lines of our fight against COVID-19, as healthcare providers, first responders, teachers, and other essential workers. Whereas immigrants have been persistent in securing their rights and access to opportunities, as well as campaigning to create a more fair and just society for all Americans. Whereas the goal of Immigrant Heritage Month is to celebrate all the monumental contributions that immigrants have made and continue to make every day. Whereas during Immigrant Heritage Month and every month, let us continue to recognize and celebrate the immigrants of the past, present, and future as we live out that meaning. Now, therefore, I, Ann O'Brien Keegren, and my colleagues recognize June 21st as Immigrant Heritage Month and call upon the community to reflect on this nation's history and celebrate the diversity of our community. And I want to see if there's anyone in the public that would like to make any comments. Let's see. We have Ray Larios. You want to unmute yourself, Ray?
Thank you, Mayor O'Brien. Hi, everybody. I just want to extend my sincere gratitude for proclaiming this month as Immigrant Heritage Month. As some of you may know, I came to America about 10 years ago seeking a better life, and I have found a home here in Burlingame, thanks to many of you and thanks to our dear neighbors here in this city. And I always like to say that we are a nation of the broken, the battered, and the bold. And this is what makes our country, and by that extension, our fair city, a great place. And so I just want to commend all of you for taking this up and making this proclamation. Thank you.
You're here.
Thank you, Ray. Is there anyone else from the public? Or in Megan, do we have any written comments that may have come in?
We do not.
Okay. All right, I'm going to close public comment. That leads us to public comments. I'm going to reopen it again, but this is when members of the public may speak about any item that is not on the agenda. Members of the public wishing to suggest an item for a future council agenda may do so during this public comment. The Ralph M. Brown Act prohibits the city council from acting on any matter that is not on the agenda. So I'll reopen the public comment. Sandra Lang.
There we go. I unmuted. Thank you. Good evening, Mayor Keegren, O'Brien, and honorable council members. First of all, I had another comment to make, but it is really wonderful to hear how we really value our immigrant population and everyone that makes this community a warm and wonderful place. I'm going to talk about heat tonight, and really I'm going to keep my remarks brief. But as it appears likely that we will experience more extreme heat, it's not a very great thing to think about, but that's a fact. I'd really like to urge the city council to designate a cooling center or cooling locations for public access, because it appears that this will probably happen and be extended. And I think it's better to be forewarned and prepared than to wait until it's upon us. So I think that will help, particularly a lot of people who might not have air conditioning or who might even be out enjoying, our city. So thank you very much for hearing this.
Thank you, Sandra. Next, we have David Menke. Do you want to unmute yourself, David? There you go.
I thought, is this meeting about the wireless program coming to Burlingame?
That is on our agenda. We are not there yet. So if you just want to hang on a little bit longer, when we get to the item, we can have public comment again.
Thank you so much.
You're quite welcome. Is there anyone else that would like to talk about anything that is not on the agenda this evening? Okay, if not, I will close the public comment. Megan, did we receive any written comments?
We did not.
Okay. That'll lead us into the approval of the consent calendar. Colleagues, would anyone like to take anything off?
Madam Mayor, I don't have an item to remove, but I was struck that we didn't have minutes on the consent, which we normally do. And I wondered if that was just an oversight and we should correct it next time, just an administrative comment.
I think, Megan, that'll be coming onto our next packet, correct?
Yes. All the minutes will be there for you to enjoy.
Thank you. I can't wait.
All right, is there anyone else that would like to pull anything off? Okay, if not, I will go.
Make a motion to approve the.
Well, wait, I have to go to the public first.
Oh, I beg your pardon.
So is there anyone from the public that would like to pull anything off the consent calendar? Please raise your hand. Okay, if not, Megan, any written comments in regards to taking anything off the consent?
No, there's not.
Very good. Then Councilmember Brownridge, do you want to move forward with the motion, please?
The motion, I think in 10 years, I don't remember a time of making a motion to approve the entire consent calendar without one item coming off it. So that's my motion.
Second.
All right, motion made by Councilmember Brownridge, seconded by Vice Mayor Ortiz, and this is to approve the consent calendars, items 8A through 8H. Megan, can we have a roll call, please?
Councilmember Beach,
Yes.
Councilmember Coulson,
Yes.
Councilmember Brownridge,
Yes.
Vice Mayor Ortiz,
Yes.
Mayor O'Brien.
Yes, so motion passes 5-0. All right, now we will move on to our public hearings. We have 3. Well, no, we have 2. Today. We're going to start with, actually we have 3. Sorry, I was right the first time around. We're going to start with item 9A, which is introduction of an ordinance of the city of Burlingame repealing and replacing the city of municipal code chapter 25.77 and chapter 12.11 to title 12 resolution establishing design and location standards for wireless facilities in public rights of way and utility easements and on public and private land, and establishing standard permit conditions, resolution approving the form of a municipal facility license agreement for small cell wireless facilities installation, and authorizing the city manager to execute and amend the agreement, resolution establishing a deposit for wireless permit applications under chapter 12.11, and establishing a fee for wireless permit appeals under chapter 12.11, and authorizing the finance director to amend the master fee schedule. We will start out with the staff report. And is it Scott?
I'll have it tonight, Madam Mayor, and I apologize for that title, but great job getting through it. Let me get my screen set up here real quick. All right, can everyone see the PowerPoint? Great.
Yes.
All right. Good evening, Madam Mayor and council members. As you said, the next item is the city's proposed update to our wireless ordinance, which would amend chapter 25.77 of the BMC, which is our current wireless communications facilities code, and would add a chapter 12.11, which would govern wireless facilities in the public rights of way. The item also includes a resolution which would provide design and location standards for wireless facilities in the public rights of way and on public and private land, a resolution setting wireless permit application fees, and also another resolution approving the form of a municipal facility license agreement. We've also provided a draft of the municipal facility license agreement itself in the packet today. So first, I want to provide a quick roadmap before we dive into the update itself. It will begin with a quick procedural note, followed by an overview of the current legal landscape for telecommunications law. While we received much of the same information from Ms. Gail Karish, who's the city's navigator in this, during April study session, proposed ordinance makes much more sense when we consider its legal context. We'll then do a brief overview of the ordinance, the accompanying resolutions, and the facility license agreement. Finally, we will end with questions for staff and Ms. Karish. We also have Planning Manager Ruben Herron and Transportation Manager Leisha Mai available tonight for questions, and their work was invaluable in this proposed update. So what is City Council being asked to consider? Well, we're asking that you consider everything that's included in the item, the ordinance, resolutions, and the municipal facility license agreement. This is because all of these documents work in tandem to create the wireless update and are somewhat interdependent. However, we're only asking that you consider action on the ordinance itself. If City Council wishes to adopt the first reading of the ordinance, it can instruct the city clerk to bring it back for second reading. We would then present the additional items, the resolutions and the facility license agreement to City Council for action during that next public hearing. So one question you might have is whether you can adopt the first reading of the ordinance tonight, but still recommend changes in the other documents. And the answer to that question is likely yes, unless those changes would require a change to the ordinance itself, which would then require reintroduction. In fact, staff has very recently received comments from multiple carriers which have not yet been considered and may make minor changes to the accompanying resolutions in the agreement based on these comments and any other public comments prior to the second reading. Of course, staff would only make those changes so long as they are not inconsistent with your direction tonight. So that concludes the brief overview of the procedural issues and brings us to the next portion of the presentation, which is the law, the boring stuff. Since this change is being driven by the many updates to telecommunication law over the past decade, I thought it would be helpful to understand the history of wireless laws in Burlingame, as well as a brief overview of the changing nature of wireless laws at both the state and the federal level. So on February 6, 2012, the Burlingame City Council adopted ordinance number 1870-2012, the city's wireless communication ordinance. This is the ordinance that's still in place today. The ordinance was designed to establish policy standards, procedures related to the siting of wireless communication facilities in a fair, equitable, and rational manner. But while it was passed only 9 years ago, the laws surrounding wireless communication facilities have changed in great part due to the rise in popularity of cellular devices over that decade. The current state of the law still allows for local governments to be responsible for siting wireless facilities, but it also limits the government's ability to do so. The original federal law, dating back to the mid-90s, is 47 USC 332 C7, which requires all those things you see on the screen in front of you. It requires actions to be done within a reasonable amount of time, provides that local regulations and placement decisions may not prohibit or effectively prohibit provision of personal wireless services. Requires that denials must be in writing and supported by substantial evidence, prohibits any consideration of RF emissions in siting decisions as long as it meets FCC Commission standards. Does not allow unreasonable discrimination among providers who provide functionally equivalent services, so in essence, the carriers, and provides for expedited appeals to court. While this law did exist during the city's last update in 2012, there are numerous additional federal and state regulations that have come into force since that time, which place various new restrictions on local permitting processes. I'll touch briefly on a few of these updates, which are explained more in depth in the staff report, if you'd like to refer to it. The first is the ban on moratoria. So in 2018, the FCC adopted what's been referred to as the moratoria order, which means that a city can't put a hold on accepting or processing applications to study and address potential issues. Therefore, it is up to the municipalities to amend their codes to ensure they're in line with the federal law. Next up are the updates to the shot clocks and the enhanced remedies granted when they're missed. These shot clocks, much like their counterparts in basketball or chess or numerous other things, are put into place by the FCC to require wireless applications to move quickly. I'm also going to give a quick history of these shot clocks because they are a major part of why our code needs to be updated, so please bear with me. Since 2009, the FCC has adopted a total of 5 shot clocks, or timelines, within which a city must act on applications for wireless facilities. The most recent shot clocks have focused on small wireless facilities and modifications to existing wireless facilities. The 2009 shot clocks established 2 shot clocks for local action, a 90-day shot clock for co-locations, and a 150-day shot clock for all other types of wireless applications. California later adopted AB 57, which is a state law that took effect back in 2016 and created a deemed granted remedy for applicants if the local government failed to act on an application during the time period allowed by these 90 and 150-day shot clocks. Another change was regarding small wireless facility shot clocks. On September 26, 2018, the FCC adopted another order known as the small cell order, which created even shorter shot clocks, 60 and 90-day shot clocks for small wireless facilities. It also interpreted existing shot clock regulations to require local public agencies to issue all relevant permits and authorizations within the short time period. So not only do you have to act on the application itself, but we also have to issue all relevant permits and authorizations in that 60 or 90-day period for these small cells. And it also provided that a failure to act within the applicable time frame would presumably constitute an effective prohibition, which would be illegal. And finally, I quickly want to speak about eligible facility requests. In 2012, Congress adopted a law requiring that certain applications to modify or add to existing wireless facilities must also be approved at the local level. In 2014, the FCC adopted an order implementing it, which included heightened size criteria and a 60-day shot clock to process these eligible facility requests. Failure to act within this FCC shot clock period can result in the application being deemed approved under federal law. So what does all this mean? It means that cities have an increasingly short amount of time to act on wireless applications from carriers, and our powers to regulate the activity depend on our processing these applications in a timely manner. If we don't meet the timelines, an application could be deemed approved by federal or state law. The proposed ordinance before you today is to ensure that we can meet those timelines. There's also been a lot of back and forth on a city's ability to control various aspects of the design of these facilities. However, the most recent law, the one that's in effect today, allows cities aesthetic regulations for small wireless facilities if they are reasonable and published in advance. And it's important to know that reasonable also means that they are technically feasible for the carriers to implement. Planning Manager Ruben Huron will speak about Burlingame's proposed design and location standards in just a few minutes when we get to that resolution. So what are we proposing? To ensure we can comply with the laws described moments ago, staff is proposing a wireless update comprised of the following items, which is the ordinance, a resolution for design and location standards, a resolution approving the form of a municipal license agreement for small cell wireless facilities, and a resolution establishing a deposit for wireless permit application fees under Chapter 12.11 and establishing a fee for wireless permit application appeals. And we're asking for potential action on, again, tonight, we're only asking that you look at the ordinance itself. So now I'll briefly talk about the proposed ordinance. The ordinance would amend Chapter 25.77 of the zoning code, which is the wireless communications facility code that is currently in place, to remove regulations pertaining to wireless facilities in the public right of way. Those are now going to be covered by a new chapter, Title 12 of the municipal code, discussed below, 12.11. The other amendments to Chapter 25.77 update definitions for key terms, modify the procedures to allow for more streamlined review of applications, which of course are subject to those short shot clocks, and as well as for small cell facilities, co-locations, and eligible facilities requests. So who's going to be the review authority for these to meet those shot clocks? Well, in 25.77, it's going to be the Community Development Director. They will be the reviewing authority for an administrative use permit for wireless facilities, and any subsequent appeal of the director's decision will be to a hearing officer. The Planning Commission will continue to hear and decide those applications at notice public hearings, and appeals of Planning Commission decisions will continue to be heard by the City Council. So for those that aren't an administrative use permit, but rather a conditional use permit, for a major facility, that still will go in front of the Planning Commission with an appeal up to the City Council. Again, this new AUP process is done to ensure we're able to meet those quick shot clock timelines that I spoke of earlier. The ordinance is also going to amend Title 12 of the Municipal Code to add Chapter 12.11, which will be called Wireless Facilities in the Public Rights of Way. For all wireless facilities in the public rights of way, the ordinance provides the permit and review standard procedures as well as the operation and maintenance standards. And who has review authority here? Well, due to the timing concerns, The ordinance establishes an administrative process in chapter 12.11 as well, similar to that in chapter 20 in title 25 for taking action on these applications in the public right of way. In this instance, the public works director will be the reviewing authority, and no applications in this chapter would be heard by the planning commission. The next couple slides are going to talk about notice and appeal rights. To ensure transparency with both the public and the applicant, the proposed ordinance creates an administrative review process with clear notice requirements. The procedure is almost identical in both chapter 25.77 and chapter 12.11. Notices of the director's proposed decision on a wireless application would be mailed to all property owners, which lie within a 300-foot radius of the proposed wireless communication facility. They would also, of course, be sent to the applicant. The notices would include a project description and site plan, a map depicting the location of a project, a summary of the proposed approval, and the effective date of the proposed approval, as well as how to submit an appeal. Brings us to the appeals themselves. Any person adversely affected by the director's decision for an AUP or a permit application under chapter 12.11 may appeal that decision to a hearing officer appointed by the city manager. The hearing officer is going to decide the issues de novo or brand new. They'll hear it without any background that could affect them or prejudice them. And the written decision will be considered for the final determination by the city. All right, so now we've gotten to the resolution for design and location standards. Another major aspect of this update is going to be that resolution. The resolution would adopt design and location standard for wireless facility in the public rights of way, as well as in utility easements and on public and private land. And it will also establish standard permit conditions for those facilities. This includes design and location requirements for wireless facilities that are placed on utility and light poles as well. I'm going to pass the baton over to Planning Manager Ruben Heron now to explain the proposed design and location standards in a little bit more detail.
Thank you, Scott. If we go to the next slide, there we go. As Scott noted, the design and location standards would apply to wireless facilities in the public right-of-way and utility easements and those on public and private land. Next slide. Within the right-of-way, there are general standards applicable to all facilities with regards to visual criteria, location, number and mounting of the wireless facility on poles, and equipment, among others. More specifically, design standards are provided for the type of installation, including utility poles, existing and replacement streetlight poles, and new poles. They include visual criteria, guidance on location within the right-of-way, and height and size standards. With respect to size, the standards require that the antenna, including the shroud, be no greater than 15 inches in diameter and no more than 48 inches tall, and that the equipment be no greater than 9 cubic feet in size and project no more than 18 inches from the pole. Next slide. These standards are consistent with the design of small cell facilities recently installed within the right-of-way. On your screen, you see the installations at 1800 Hillside Drive and 1505 Bernal Avenue. 3 other similar facilities have also been installed in Burlingame. And what you see on the screen here, those installations follow those standards that we have in the resolution. Next slide. With respect to location, the standards discourage installations on non-arterial or local streets within residential areas. They also prohibit installations within the right-of-way on Burlingame Avenue and Broadway within those downtown districts. To clarify, the prohibition would only apply to these streets, Burlingame Avenue and Broadway. They also discourage small cell facilities from being closer than 300 feet from one another. Next slide. Moving on to wireless facilities within public and private land, the design standards include guidance on stealthing and concealment and requirements for rooftop and wall-mounted installations on buildings. These design standards are in our current wireless ordinance, so there aren't any significant changes with that regard. With respect to location standards, the ordinance first encourages placement of new facilities with existing facilities. It then encourages placement in commercial areas which are not within the Burlingame downtown districts, then within the Burlingame downtown districts, and lastly, within residential districts. That provides a brief summary, but I'll hand it back to Scott at this time.
Thank you very much, Ruben. Moving on, we do have a couple more resolutions. I promise we're getting near the end here though. So the next resolution we want to briefly update you on is the resolution for new wireless fees. This resolution would establish a deposit in the amount of $1,000 for Public Works to request of applicants, generally carriers, before review of their applications under Chapter 12.11. There's currently no fee that would cover this review as it stands today, as the chapter establishes a new permit and process. Applicants under Chapter 12.11 will no longer be subject to those permit fees for review that currently exist and do exist under Chapter 25.77. The city chose to establish a deposit rather than a fee to ensure that we don't run afoul of the FCC's requirement that a fee not exceed a city's reasonable costs. Of course, with the deposit, we are charging reasonable costs because that's what we're charging against the deposit. If the deposit be depleted, the city will require reimbursement before additional work is done. The resolution also creates a new wireless permit appeal fee of $600, which will be collected when a party appeals a director's decision, either the community development director or the public works director's decision on a wireless permit application. The $600 fee is inclusive of noticing costs related to the appeal. The next resolution would approve the form of a municipal facility license agreement for small cell wireless facilities installation on our city-owned poles. The resolution allows the city manager to execute the agreement and to make amendments to it if necessary. And then of course there is the form MFLA, or the Municipal Facility License Agreement itself. And the agreement itself is a template agreement for the city to use with carriers who want to place wireless facilities on city-owned poles in the public rights of way. The city currently owns approximately 1,130 of these poles. The main terms of the agreement are that the initial term will expire after 10 years. It will require that $1,000 deposit we just mentioned in the earlier resolution. And because of an FCC ruling, it'll charge an annual rent of $270 per location. If this FCC declaratory ruling, which is currently the subject of litigation, is no longer enforceable, then an alternative rent in the amount of $1,500 per year per location will be charged immediately. And that's it for the substantive portion of the presentation. I will note that a recommended procedure and order of operations can be found on page 2 of the staff report, which is meant to assist you in navigating this fairly complex item. And with that, staff is available to answer questions. Ms. Gail Karish, a partner at Best Best & Krieger and the city's navigator through this complex update, is also available to answer any questions and of course, correct anything I got wrong. So with that, thank you very much. And we're here for questions.
Thank you, Scott. All right, so we will first start out with questions. Colleagues, does anyone have questions? Okay, I have a couple. So the hearing officer, who exactly is the hearing officer? Would it be our city manager?
So currently it
Or
would
is it
not be
someone
our
from
city.
the outside?
It would be someone, right now the belief is though will be someone that we contract with on the outside who will be the hearing officer for the city in this and potentially in other instances where we need a hearing officer. But they will be an independent hearing officer, not
Okay,
someone
so
on
it is
city staff.
independent. Okay, very
Yes.
good. The other question I have is in regard to the 10-year initial permit. Is that negotiable at all?
I'm going to
How did
let
it come up 10 years?
I'm going to let Gail Karish answer that question because I know there's a law on it, but I don't know the exact site, and I'm sure does.
Thanks, Scott. Good evening, everyone. So there is a state law that allows cities to limit a wireless permit to 10 years. And so that's one of the conditions of approval, standard conditions of approval. And that I think is in the packet in the resolution that has the design and location standards. The 10 years that was mentioned in Scott's presentation was the initial term for use of a city-owned pole. So if a carrier signs an agreement with the city, you authorize the use of a city-owned light pole, that would have an initial 10-year term. And I think the thinking was just that, it's commensurate with the permit that's going to be issued for that pole as well.
Okay, thank you. And then the other question I had is on page 8 of the ordinance. It mentions voluntary pre-application meeting. Can we make that mandatory?
Scott, did you want me to answer that one too?
Yeah, Gail, can you take that one?
Sure.
Thank you.
Sure. So you can make it mandatory, but the problem with doing that, and why we propose it as voluntary, and I think strongly recommended, is that any mandatory act starts your shot clock. So if you were to have a mandatory pre-application meeting, then your 60, 90, whatever day shot clock starts the date of that meeting.
Okay, very good. Thank you for that explanation. Councilmember Brownrick.
Thank you, Madam Mayor. So appreciate all the hard work and looking forward to bringing our code up to speed, looking forward to input. There were a couple of items that were not on our design location parameters. And I remember the heritage of this ordinance very well. I think early on we were trying very hard to really discourage any kind of equipment coming into residential neighborhoods. And that's why we really tried to encourage much larger cell sites going on top of big buildings. And we all recognize that we were trying to hold back the tide like King Canute. And finally, the tide has overwhelmed us. So the cell sites are going to be in neighborhoods, and that is irreversible. So with that in mind, and I do appreciate a lot of the work in here that is going to make sure aesthetically we're in as good shape as we can be. But there are a couple of things that aren't in here. One of which is the notion that antennas should be as far away from homes as possible, or in the city of Palo Alto, at least, they proposed a 20, I don't know if it got passed, but they proposed a 20-foot minimum. And so I note that that's not in our ordinance. I also note that much of this electric equipment will have fans to cool it. And we don't cite, well, we do have a noise regulation that's the Burlingame municipal standard, but I don't really know what that means. And I worry that we should have stricter standards for fans that are in neighborhoods that are on all the time. And so my generic question here is, are these the kind of issues, and I have a couple of others, that I should wait until that part of the resolution comes back next time, Mr. City Attorney? Or is now the time? I understand from the staff report that we're trying to do kind of the umbrella ordinance here, and then we're coming back with specifics. So I don't want to bog us down in specifics, but if this is the time to do it, then I will put my questions or hopes on the table.
So you can definitely give feedback on those today. We're just not asking that you take action on those resolutions or the agreement itself, but we do want to know what council believes should be changed. That being said, I think Ms. Karish may be able to address some of those concerns with a response. So I'd say bring them up today. We can talk about them. They have been agendized. We are fully able to speak about them. And then staff can consider those to bring back with the second reading of the ordinance, should the council choose to adopt the first reading.
Ms. Karish, do you want me to I don't have a lot of them. I just have one or two other ones. Shall I lay them all out?
Sure.
So I think the way we set up our order of preference, and I appreciate it, it was done with aesthetics in mind, was to not have equipment on the corners where they're going to be more visible. But again, I think most residents who are concerned about this are concerned about aesthetics, but are actually concerned about health. And I know the FCC doesn't permit us to take that into account. Nevertheless, an awful lot of residents do care about that. So I wonder whether we should not preference internal locations over corners if the internal location is closer to homes than a corner. So that's one. I would like to see a stricter noise standard for fans. We don't stipulate distance from schools or daycare. Don't know whether we should. Other cities have. I'm inclined to say yes, but I wanted to raise the question. And glad that we're insisting that any unused equipment get demoed. I'm a little discouraged that it takes us a year of inaction before they have to do it. But and then I guess finally, the standards for sidewalk equipment. And I appreciate that we encourage vaults, but the line in the ordinance is something like you can put equipment on the sidewalk if that's the only technically feasible solution. And I worry that many operators will just tell us that it's the only technical feasible solution because it's less expensive. And I am really concerned about cluttering sidewalks. And I don't know whether there's more we can do to define what technically infeasible means, because right now it seems vague to me. So I'll start with my highest priority, which is to have a minimum distance from homes that a cell tower is allowed to be. Thank you for that.
Okay, so just to be clear, are those things that you want me to, items that you want me to address, or are you just giving some
Well, maybe I want to, in order not to
preferences?
bog us down, I can lay that out for our city attorneys and you as issues I'd like to see addressed. And then you can tell me next time why we're either not allowed to or we can. That's fine.
That sounds good. Thank you.
Okay.
Thank you, Councilmember Brownrigg. Actually, you had triggered something while you were speaking. And I may just lay this out too, that to come back at a later date. And it's in one of the resolutions, and I can't remember which one, but there was something in regards to if there's graffiti, that it needs to be cleaned up within, I think, a 2-day period. If it isn't done within that 2-day period, or if it's a 3-day period, whatever was stated in this report, can we implement a fee if it's not done during that certain time period? And then for every day that it's not done, that there is a continual fee until it has been taken care of. Okay, Councilmember Beach.
Thank you, Madam Mayor, and big thanks to Ms. Karish and our Assistant City Attorney, our City Attorney and staff for the presentation. I I appreciate you did a good job of laying out for members of the public who may be joining us for the first time that our hands really are tied by federal and state law. So, we're doing the best we can to control the aesthetics and what we can. So I have two questions. One that's just dovetailing a little bit on what Councilmember Brownrigg was speaking about, but I recall from past conversations, we had a thought process that said, in order to sort of limit proximity to residences, that we would have a preference to consider even our parks and open space, because people don't sleep nearby, for people that are concerned with some of that. And on page 9 of the design guide, bullet number 3, it mentions how locations in residential zoning districts, how they're integrated, maybe designed to blend with open space and playing fields, parking lots and parks. But it didn't seem like that's a real explicit preference. And I'm wondering, perhaps I missed it. This is a large document, but is that something that we've contemplated, like a preference for those public open spaces? And if not, maybe could we think about that before it comes back, would be one thing. And then I'll pause there for my other question.
Councilmember Beach, is that the only question you have?
No, that was my first question, but I did have one other follow-up that's unrelated. So I don't know if staff or Assistant City Attorney Spancel wants to address that, or Ms. Karish, or we can address that at our next meeting.
I would suggest, if I may, that Ruben might want to address it. I think that to a large degree, at least outside the right of way, we're just sticking with the kind of provisions that you had already in your code. And so maybe there's some more need to do some integration on that point, but Ruben would have a better sense of that than me.
Sure. I mean, it's something that we can consider. If it's the council's desire, we can make that more explicit. If your desire is to specifically list parks and open space as higher preference in the order, please give us that feedback. We can certainly, right now, the way it's worded, I was just looking at it, it is not clear that that's a higher preference order. It's more of an example, but certainly we can take a look at that. We do have one installation at Washington Park. It's the large light standard for the baseball field. So, it is possible to put them in parks and open spaces.
Okay, thanks for considering that. There's trade-offs and pros and cons to everything, but would appreciate staff's, thoughtfulness on that and colleagues' thoughts as well. Because I do agree, Councilmember Brownrigg, I think a lot of people, even though we are not allowed to contemplate the RF, that's just not an issue we can legislate, but I think that is an underlying concern with people. But regardless, the other question, and actually it's a thank you. I love the fact that this includes an alternate rent should the $270 somehow be lifted, that automatically it defaults to $1,500 a pole. And I think that's really smart thinking, because one of the concerns I think local jurisdictions have is where the community benefits for this. Sure, we've got 5G, but many cities prior to this legislation that really capped these, that really don't even cover the fees, really were able to reinvest funds back into the community. And so I'm just wondering about that $1,500 price point. Was that sort of a going rate for what people were charging before? Or is that sort of a best practices that would be a good number to have, or where that number came out of? That was my question.
I can take that one, if I may. There were agreements negotiated in various jurisdictions, just market negotiations that came out sort of all over the place. And it was like any kind of property sort of negotiation, right? How do you kind of compare this city to that city? Some cities were real outliers, and they got, they were like the poster children when the industry was trying to get legislation. And I will say there is currently a bill in the Senate. I mentioned it in my prior presentation. So we may well find, if that bill does get signed into law, that you're back to 270 under state law as well. But 1,500 was in the range of what we were seeing in your area at the time. San Francisco was a little different. That was significantly higher, but also considered an outlier. So that's about the middle of the range, and comparable to what we saw in a fair number of samples that we had in the region.
All right, thanks for your proactive approach on that. We appreciate the heads up play. Thank you. Thank you for your work on this.
Oh, you're welcome.
Councilmember Coulson.
Thank you. So I have sort of one follow-on comment and two questions. The follow-on comment follows on to the mayor's question around graffiti. I guess I would just add in there as well. Say, for example, a car hits a pole and damages the equipment and we have loose wires. So anything like that, graffiti or any damage to the equipment, whether it's Mother Nature or an accident or anything, needs to be repaired. So graffiti and damage within a certain amount of time. And while we probably can't manage the repairs, I think, not that our city staff has a lot to do already, but I'm almost like, if rather than find them every day, I don't mind doing that, but I'd almost rather just get it cleaned up, let our people clean it up, and then charge them. Like, we should be able to bill them back for our costs to have to clean it up if they don't get it done within like 48 hours. Otherwise, they may be okay just paying some fee and it sits there for 2 weeks. So just kind of adding on to her very good initial idea. And my two questions are, the first is around notification. So I think one of the biggest problems that we've had as a council with this is this notion of notifying the neighbors. And so how do we think about letting people in the city know what the laws are and how they've changed and kind of how our hands are tied, whether it's an article in the news, e-news, or it's a public session or a study session or something, or written communication in the water bills. I'm not sure, but it seems to me like we should be proactive about this. And then how, when there's a poll going up, how far out is notice? Is it just 300 or is it 500 again? That's question one.
It's just 300 as proposed right now.
So 300 covers like 6 houses either direction and a few houses across the street. Okay.
Depending on where the location is. But
Where the location goes. Okay. And then if we start getting a lot of complaints about that, like I didn't know this was going in, I live half a block away, I hope you'll keep track of that and maybe expand that to 500 if we get a lot of complaints. And then maybe just for staff thinking about how to communicate this out, doesn't have to be answered today. And then my next question is, can you tell me, like, what would a legitimate appeal be? And the reason is I ask this is because I really worry about people spending $600 to appeal these things on the RF or appeal these things on something that they really aren't going to be able to get it appealed on. So do we have a set of standards by which you should, these are things that would logically meet an appeal, and the company doesn't comply with the exact specifications for what they're supposed to put up there. For example, they put it on the wrong pole. That's an appeal. So I guess I just don't want people paying $600 appealing these things and having these things getting all gummed up when they're really never going to win the appeal.
I think that's something we can definitely take care of, not by changing the ordinance, the resolutions, but just with our public outreach, which we've been doing quite a bit of public outreach to make sure the message of this got changed. But we can make sure that the postcards that are being sent out to those being notified can point them to a direction which will better explain, like you said, what can't be considered an appeal. At least we don't want to tell people that this is the only kind of successful appeal, but we can certainly tell them the things that would not be allowed to be considered.
I think that's a really helpful thing, so that people aren't, $600 is a lot of money for people, and I don't want people to be appealing things that they're just never going to be able to have resolved.
Absolutely. I do want to note that the $600 is to get the appeal hearing. So technically people would not have to individually pay it if a couple people in the neighborhood wanted to appeal something together. They would both be able to make an appearance at that hearing.
Perfect. So they could get together 4 or 5 neighbors and appeal something and pay $100 or $150 each. Okay.
Yes. Sorry.
No, thank you.
Thank you, Councilmember Coulson. Vice Mayor Ortiz.
Thank you, Madam Mayor. And it's pretty sad to watch how we have no control over this, and we're trying to amend these things just to fit these crazy laws. And so we're very limited as to what we can do. And but some of the things that my colleagues brought up, I just want to go back to minimum distance from schools and homes, noise, clutter on sidewalks, and the graffiti and the maintenance. I think those are all very, very good points. And I'm just curious, have other cities passed ordinances that include these, having a minimum distance from homes and schools, having some sort of maximum noise levels? The sidewalk one's a little tricky, but I wish we could figure that one out, because I agree with Councilmember Brownrigg that if given an inch, they will take it. And then the graffiti and maintenance, I'm just curious if other cities have passed these and how they've held up.
Gail, are you able to speak to that at all?
Sure. I can give you just sort of based on my experience of what I've seen. I would say noise, that's a common requirement that the noise ordinances be met. And sometimes what you see in these applications to address noise is that they use passive cooling, which may mean if they put it in a facility in a container, it's a larger sort of cabinet that allows for passive cooling to avoid noise issues. One of the trade-offs with undergrounding is typically if there's undergrounding, then you have no choice but to have some sort of fans to maintain the cooling, because the passive cooling usually work. On sidewalk clutter, we do, that's your city's strongest sort of right-of-way regulation is to avoid not only clutter, ADA compliance, all of those things will be considered safety hazards. So, it can't be, a box can't be put at a spot where it would block a driver's ability to see around the corner. So that's classic right-of-way regulation. And so all of that is, there's no question that you can regulate those sorts of issues. The graffiti, same kind of thing. That's, kind of classic right-of-way regulation, keeping your health and safety, public health and safety kind of issue. The minimum distance from homes and schools is a little bit more tricky issue because we do see jurisdictions adopt those kind of standards in some places. It becomes really, from a carrier's perspective, the issue of compliance will depend on whether they can both comply with that requirement and meet their own service needs. So sometimes that's where you see, especially in jurisdictions where they impose really lengthy kind of setback requirements from distances from those sorts of facilities, where it becomes very difficult for a carrier to find a location where they can both meet that requirement and place their facility where they need to place it. So sometimes there can be conflicts because of those, but only the most draconian ones can actually end up in a carriers making a claim that just on their face, your regulations violate the law and don't allow them, are effectively prohibiting the provision of service. More modest ones sometimes will still be workable, but the other thing that we have in the ordinance, and you don't want to rely on it too heavily as like regulating by waiver, but there is a waiver process that allows for sort of a safety valve if you do have issues of infeasibility or other particular applications where the applicant just cannot meet all of your standards. It can demonstrate a good reason for not being able to do so.
Is that all your questions, Vice Mayor?
Yep, that's all I got. Thank you.
Very good. So before I move forward to have the city clerk read the title of the ordinance, I had one last question. And it's in one of the, I think, resolutions where it talks about the antenna should be at the smallest possible size. So say, for example, it's put up, they have the permit for 10 years. After that 10-year period, they would have to renew for a permit. So then at that time, if the technology has improved and you have much smaller equipment, would they then be required at that time to go with the smaller equipment?
They would have to apply under whatever your standards are 10 years from today when they're renewing. It'd be like applying for a new permit.
Okay, very good. Thank you. All right, if there are no other questions from my colleagues, can we have our city clerk read the title of the proposed ordinance, please?
An ordinance of City Council of the City of Burlingame repealing and replacing Chapter 25.77 Wireless Communications Facilities of Title 25 of the Burlingame Municipal Code and adding a new chapter, Chapter 12.11 Wireless Facilities and Public Rights of Way to Title 12 of the Burlingame Municipal Code. CEQA determination exempt pursuant to state CEQA guidelines, sections 15378, 15061B3, 15302, 15303, and 15304.
I have a motion to waive further reading and introduce the ordinance.
So moved, Madam Mayor?
Okay. And then Megan, do I need to do roll call on that before I conduct the public hearing?
Yes.
Okay.
Councilmember Beach,
Yes.
Councilmember Colson,
Yes.
Councilmember Brownrigg,
Yes.
Vice Mayor Ortiz,
Yes.
Mayor O'Brien.
Yes. All right, so I am going to open this up to public comments. First, through our city clerk, do we have any written comments?
We do not.
Okay, very good, thank you. So I will go to our public comments, and I have Maureen.
Good evening, Mayor O'Brien, Vice Mayor Ortiz, council members and staff. My name is Maureen Cruzen and I'm with Verizon Wireless. And I'm here tonight to urge you to not move this ordinance forward for a second reading, but instead to direct staff to meet with Verizon and other wireless carriers so that we can provide input. While we appreciate staff's efforts to update the existing wireless ordinance and bring it into alignment with current state and federal law, there are several problematic items in all of the documents presented in the agenda packet that could materially inhibit our ability to build our network. I thank you for your time, and I look forward to the opportunity to work with the city on revising the draft documents.
Thank you. Next is Ellen Kame, and I apologize if I'm pronouncing it incorrectly.
Hello, can you hear me? Perfect. Okay.
Thank you.
Great. Thank you. So good evening, Mayor O'Brien, Vice Mayor Ortiz, and honorable council members. My name is Ellen Kame. I'm part of the External and Legislative Affairs team with AT&T. We appreciate the opportunity to work with the city and staff over the last several years on tonight's design guidelines and MLA. We submitted comments and suggestions to city staff prior to the meeting, but know that we were maybe a little bit too late. So we look forward to tonight's approval of the item to continue to work with the city to bring connectivity, which is crucial for continued working from home, telemedicine, e-commerce, public safety, and families. Thanks so much.
Thank you. David Menke.
Thank you. There it is. Thank you all for letting me listen in on this interesting discussion. And I had another point of view than most of the people, the board and your office who drafted this. Is I just wondered if we've made this too onerous for the companies who want to provide this communication for us. I would hate to be left out in this communication revolution because we don't have good enough wireless connections. And so I guess my question to you is to ask is, have you asked or spoken to the carriers at all, and how onerous do they find this? Thank you.
Thank you. Scott, do you want to talk about that now, or do you want to wait till I close the public comment and we'll address the couple things that came up?
After you close the public comment, we can address those concerns.
Very good. Thank you. Is there anyone else that would like to speak on this topic? Jason. You need to unmute yourself, Jason.
Can you hear me?
There you go.
Okay. Council member Brownrigg mentioned some technical requirements, and I didn't see in the presentation of what would the carriers have to present to make a convincing case for, what the technical requirements are for why they're placing the antennas where they are placing them.
Okay, Jason will note that question. Anyone else? Okay, if not, we'll close the public comment. And we will go back to my colleagues and actually to staff to address some of the questions that came up. So one of the questions is to meet with the utility companies, which I know we've done that over the last couple of years, but you may want to address that further. And then the technical questions that the last gentleman brought up.
So I'll try to address the first question, Madam Mayor, and that's the consultation with the carriers. We are actively trying to work with the carriers. The comments did come in very late after the agenda posting, so we haven't had a chance to make those conversations, find any fruit from those conversations in terms of moving forward. But the way that this has been presented tonight, we do have the draft ordinance in front of you for consideration. The other documents, the resolutions and the license agreement, are something that we can still tweak as long as council does not have an issue with us talking to the carriers, considering their issues and considering any issues from the public as well. We can continue to work those documents before they come back to you in 2 weeks, should you choose to adopt the first reading of the ordinance. I will pass along the technical aspect to Ms. Karish because I am sure she has a much better answer than I would.
Before we do that, just to clarify, Scott, so we are basically, just for the public to know, we are basically just voting on the introduction of the ordinance this evening. Anything that relates to the resolutions will be coming to us at the next meeting.
Absolutely. It's there for you tonight because the context of it, it's very hard to consider the ordinance without considering the rest of them. And I did forget to mention, we have been alerting the carriers throughout this update to make sure that they were aware with the latest drafts of the documents that we had. So we are trying to engage with the carriers and the public to make sure that those interested in this update do have a voice and they're able to tell us their concerns. So we will continue to do that as well.
And then also for the public, our staff has been writing down all the questions that my colleagues have had this evening and the public. And so those will also be addressed again when it comes back to us the second time.
Can I ask a point of clarification, Madam Mayor?
Sure.
So as I understood the representative from Verizon, she felt that the entire package had flaws, and the representative from AT&T seemed to think it was workable. And I guess my question for our city attorneys is, as I recall prior ordinances, even if we introduce it, it can come back, or when it comes back, there is the potential for council to make amendments. Maybe it's not the preferred thing because then you have to go back out and renotice and stuff. But to the Verizon comment, even if we introduce it and publish it, it is still subject to change in the future. Am I right about that?
You're absolutely correct, Councilmember Brownrigg. You could choose to reintroduce it soon. You could choose to direct staff to come back at a later date to address other concerns, perhaps months from now. So this can always be changed. The ordinance itself, of course, is harder to change because of the noticing and public hearing requirements that we have. But the resolutions and the others can all be done in one meeting should council believe that an update is required. So we do have that as well.
Right. So, yeah, thank you for that.
Thank you, Councilmember Brownrigg. And now we were going to have the answers to the technical question.
Which I think was on tap for me. So we put in the ordinance itself the ability to request a waiver in certain circumstances, and that there are 3 listed. Right, there's prohibit or effectively prohibit provision of personal wireless services under federal law. That a denial because you're applying your location and design standards would otherwise violate applicable laws or regulations. And then we have the third, which is require a technically infeasible design or installation of a wireless facility. And that one, we don't say for any of these what would be the proof required, but it does put the burden on the applicant to provide a demonstration of an explanation of why they're making the claim and think they warrant having a waiver. And it will really depend on what they're saying, what the particular issue is to know what the demonstration would be. It's hard to kind of predict in advance. Like, to give you an example, it may be, if there's a requirement for shrouding an antenna, and certain of the 5G antennas, that if there's a typical kind of shrouding, then that will interfere with the signal. So that might be the technically infeasible requirement, and instead they can put a film on the antenna. So that's an example where there might be an argument that there's something technically infeasible about applying the design standards of that particular application, but it's difficult to know in advance. There's a lot of different things they might raise, so that they'll just have to provide the demonstration. And there is an ability for the city to hire a technical consultant to give them advice on, or vet these claims. So that's always a possibility if there's uncertainty at the staff level about whether they should accept the arguments that the carrier is making.
Very good. Are there any other questions or comments? Because if there, Councilmember Brownrigg.
I take it we're getting close to wrapping up. Is that your sense, Madam Mayor? So
That is my sense. So if there aren't any other comments, we could go forward and make a motion to bring the ordinance back for a second reading and bring back then all the kind of answers to the questions we had this evening related to both the ordinance and the resolutions.
And I will be happy to make that motion. I just wanted to very briefly personally address the two public comments. So with respect to, and I do appreciate Ms. Karish's more expert commentary, but I think the practical layman answer to the question, is the city allowed to second guess a carrier's assessment that they need more equipment? And the answer is practically no. The FCC has made it so difficult to second guess whether the technology is required in order to provide service that effectively, I don't think residents should kid themselves that the city is going to be able to look a carrier in the eye and say, we don't think you need to put the antenna there. We think you have good enough service. So that, I think, is at least from my point of view, the pragmatic answer. With respect to Mr. Kempe's other side of the question, are we making it too difficult? Time will tell, but I think that the high likelihood is that we'll see hundreds of these nodes throughout our community pretty quickly. And my sense from talking to carriers is they just want to know how to build it, but they have no doubt about their ability to build it. So I don't personally think you're going to have to worry about additional cell towers popping up, for better or for worse. That's my perspective. With that, I make a motion to introduce the ordinance as the mayor so eloquently put it.
I'll second it.
Or sorry, you did make a motion. I beg your pardon. I think my motion is to say, let's print it and bring it back for action. Is that right, Madam Mayor? Sorry about that.
Correct. And that's also including the accompanying resolutions.
Right. At which point
we'll further discuss at that time.
Exactly. Just as you put it, at that point, we'll be able to go a little deeper on some of these more specific design standards.
Okay, so the motion is made by Councilmember Brownrigg and I think seconded by Councilmember Coulson.
Yes.
I believe, Madam Mayor, did you make the motion? Just trying, no, okay.
No, I didn't make
Okay.
the motion. I think I kind of led it, but
Okay.
I let
Got
Councilmember
it.
Broderick say the motion. And then
Thank
Councilmember Coulson then seconded it.
Got it. Thank you. And I apologize.
No worries. All right. So then Megan, you want to do a roll call on that?
Councilmember Beach,
Yes.
Councilmember Coulson,
Yes.
Councilmember Brownrigg,
Yes.
Vice Mayor Ortiz,
Yes.
Mayor O'Brien.
Yes. So then I would assume this comes back at our next meeting, or would it potentially take a little bit longer if staff needs more time to address the questions that were proposed this evening by both colleagues and the public?
The plan would be to have this at you at the next public hearing on July
Okay.
6th.
Very good. All right. We will move forward to item 9B, which is the introduction of ordinance of the City of Burlingame amending Chapter 15.06 and adopting a new Chapter 15.07 of the Burlingame Municipal Code to prohibit wasteful water use practices. Determination exempt pursuant to state CEQA guidelines, sections 15378 and 15061B3. Can we have a staff report? And is this Syed?
Good evening, Madam Mayor and Council. Actually, I will have Jennifer Lee, our Environmental Regulatory Compliance Manager, make a presentation to you, which is going to be a brief one before you discuss it and do the public hearing.
Great, thank you, Director Martusa.
Thank you. Good evening, Madam Mayor and City Council members. Again, my name is Jennifer Lee, and I'm the Environmental Regulatory Compliance Manager for the city. And as you may know, the city is updating its urban water management plan, which is a long-term water resource planning document to ensure that the city has adequate water supplies to meet existing and future water demand. And there will be a separate public hearing focusing on that plan. But related to that effort, staff determined it was necessary to make a few updates to the municipal code. And specifically, we are hoping to accomplish two things. First, we want to establish the legal authority to implement and enforce the city's water shortage contingency plan. And this specific document is included in the urban water management plan. And it outlines steps that the city would take when City Council declares a water shortage emergency. So for example, in a drought, that could mean limiting outdoor watering to 2 days a week, for example. The water shortage contingency plan details temporary water conservation measures that the city would implement at various water shortage levels. And for the purposes of tonight's ordinance, we want to make sure that we have the ability to enforce that plan. And secondly, we are also recommending that council adopt a new water waste prevention ordinance. And although this is a regulatory driven by the California Water Code, it is also very timely since much of the state is experiencing drought conditions this year. And the purpose of this ordinance is to establish baseline permanent restrictions on wasteful water use practices. So many cities have adopted a similar water conservation ordinance, which is in effect year-round. And as you'll see in the staff report, the proposed restrictions we are recommending are a combination of actions that were required under the last drought from former Governor Brown's executive order, as well as some additional actions that neighboring cities have already adopted in their municipal code. Again, the intent is to target wasteful water use practices. And just like we did in the last drought, staff would take an education first approach to inform residents if they are not following these water conservation regulations. And we would reserve citations and fees and all of that as a last resort. California has a history of droughts, and whether or not we are in a wet year or in a dry year, it is always important to conserve our precious water resources. And with that, I will be around to answer any questions you may have. Thank you.
Thank you, Ms. Lee. I do have one question in regard to page 3 of the staff report. where it lists, the various water waste restrictions. There is a no washing sidewalks unless for health and safety and no runoff to storm drain. So it looks like all the cities that are mentioned have adopted that, but we did not mark that. Was there a particular reason for Burlingame?
Yeah, Syed, did you want to take that or did you want me?
Yeah, let me take that. Madam Mayor, the reason staff is not proposing those elements, as you just highlighted, is because they are good practices that we would like people to follow through. But when we adopt those into the ordinance, if somebody were to do wash their sidewalk for whatever reason, it will be illegal. And so it's a violation of the code, and it will be severe term, and it will require a lot of processes and enforcement, what have you. So do staff encourages folks to follow those good practices? We would not want to make it too difficult to enforce the ordinance, number one. And also, we do not want to create a lot of problems for the residents and businesses by generating a lot of complaints. So we wanted to, that was one of the reasons we wanted to keep that. And also the last item that you noted, that we did not want to have the director to have the authority to make changes, because then it would be difficult to have a proper enforcement, consistent enforcement, because there may be people may bring individual circumstances to waive their the requirements. So we did not want to have that.
Thank you, Director Matusa. Councilmember Brownrigg.
Thank you, Madam Mayor. I have a couple of practical questions along your lines. So one of the restrictions that we're considering is making it illegal to irrigate within 24 hours of rainfall. So we have 80 days of rainfall a year. As a general matter, drip irrigation is far more efficient than other kinds of irrigation. I'm a little concerned that making this, for somebody who has an automated system, I don't think actually it will ever get ticketed. But on the other hand, is this something that we really want homeowners to be, they're breaking the law if they leave their sprinklers on after a day of rain? I mean, I don't know. So that's yeah.
Yeah, it's up to the city council. That is one of the common thing that we found in cities. The neighboring cities do that, but the council, if you want to change that 24 hours to a different number, that would be, the idea is to essentially discourage folks to irrigate their lawn within a day after the rainfall.
I mean, I understand the logic of it. I just worry a little that we get so intrusive with some of this stuff. What is a positive shutoff nozzle on a hose?
It's the ones that have like a trigger to it.
So it has to have a spring. If it doesn't spring off, then that's not good enough. Everyone now has to get a spring-held hose thing. Is that what we're saying to people?
Yeah, and we actually do give those out for free at public outreach events. So it just can't be a hose without anything, attached to it.
Essentially, to be able to control the flow of water, that could be done through essentially shutting off a manual shut off, or by pressing the lever on the nozzle.
Well, I mean, a lot of people have devices at the top of their hose which manually you have to turn it off, or a handle, not the spring held. Spring held is hard for a lot of senior citizens, to be honest. I mean, sometimes it takes a fair amount of pressure on so again, I just worry about it being so prescriptive. And I worry that we're kind of virtue signaling, like we're so good at saving water, and we're actually kind of really nitpicking. I don't know. I will give back the floor to somebody else. I'm a little bit uncomfortable by some of this stuff.
Councilmember Coulson.
Okay, just following on to Councilmember Brownrigg's questions. What is measurable? How do we define measurable? In other words, if it sprinkles a little bit, then can you not water your lawn for 24 hours? And as we also all know, it can rain a ton up on one side of town and almost nothing on the other side of town. So I guess to me that as well goes back to an enforcement situation. It rained a half an inch, it rained for 10 minutes. I just don't know. And I agree with you that the problem I can see in like my own water system is the more I'm turning it on and turning it off and turning it on, and turning it off, the more likelihood of it getting messed up and then over watering my yard. So I agree with Councilman Brownrigg that maybe we should kind of think a little bit about that. And then with regard to the nozzles, so a lot of people use watering cans to water their pots and plants. And so they fill them up efficiently, and the nozzles are really hard to fill a watering can up. You turn them on, they spray back up at you. So to me, it's not so much about having the spray nozzle as saying, don't turn your hose on and walk around your yard and your front yard and leave it running on the front. And I don't know how to articulate that to people, but however they decide to do that, whether it's taking an open hose and putting it in a water can and then carrying the water can and watering the plants by hand, which is a really efficient way to water plants, or putting on the sprayer. In a lot of ways, that sprayers are very inefficient with water. When you put them on and spray across the whole lawn, if it's windy, it blows the water away. I don't know. I'm just, as someone who's does a lot of work with gardens and watering, I'm not 100% sure those are going to achieve the goals. I don't know that I have a better solution, but I would hope we would give warnings and talk to people about it, as opposed to being very ticketing. And maybe, we should think about putting together some incentive programs that, might help people. Say, for example, I noticed my neighbor across the street, they were watering constantly and it was flowing into the sewers and the gutters. And I know that they were trying to regulate it and they couldn't. They tore it all out and just put in artificial turf. So there's now no water. It's a much more efficient thing. So maybe there's certain things that we can encourage people to do, or a list of ways that we can talk to people about other alternatives to just water. So I guess I'm saying it's a comprehensive question and a comprehensive program, but I like the start.
Madam Mayor, if I, after hearing from all council members, I would like to address some of those questions.
Sure. Let me, I think Councilmember Beach may have a couple questions, and then we'll go back to you, Director.
Thank you, Madam Mayor. Just one question. I do appreciate staff's effort to do what we all know we need to do, which is conserve water, because we're in a super severe drought right now throughout the western states. So appreciate the effort. My question is just one that sort of Councilmember Brownrigg brought up that I hadn't thought of before, but do you think we should contemplate a difference in this ordinance between drip irrigation versus sprinkler systems? And I don't know the answer to that because I'm not an expert gardener whatsoever, but there seems to be a difference. What are staff thoughts on that?
Yeah, there are definitely, when in there, my research of other municipal codes of water conservation ordinances, some cities do go very specific in that I think this is pertaining mostly to the no application of potable water to outdoor landscapes in a manner that causes runoff. That one in particular, I think, references spray irrigation or spray or sprinkler irrigation as opposed to drip irrigation. So for some of these restrictions, we can differentiate between drip and spray or overspray.
Right. So, Madam Mayor and Council.
Before you speak, Director Matuza, I think Vice Mayor Ortiz has a question.
Yeah, thank you, Madam Mayor. I'm going to go back to the positive shut-off nozzle because to me, that tells me it's the spring-loaded one, like Councilmember Brownrigg was saying. And I believe there's other options. Mine doesn't have the spring. I would have to get a new hose or a new nozzle because mine doesn't have the spring-loaded. But you can shut it off. So when I see the positive shut-off, that tells me that's not. It's the one that I have to squeeze. Otherwise, it goes off. And secondly, I mean, again, we're going to have to deal with sooner or later with all this water issue because this is not going to be the last year of drought. This is not going to be the last drought we deal with. This is going to come back over and over again. And so we can sit here and talk about drip versus this and that and the other. The reality is if somebody has a drip irrigation system, it's going to be really difficult to see when it's watering or not. And it's going to be very unlikely that they're going to be called for. It's just a person with the water flowing all over their lawn and going down the sidewalk. That's the one that's going to be called. So I don't know that. To me, I think we have to have some teeth in this. You have some the ability to be able to do something for egregious situations. But I don't think that I don't think anybody's going to go after the guy who had the drip irrigation 24 hours after there was a little drizzle. So I'm not too worried about it. I think we need to leave the teeth in it and be able to go after it. So yeah, again, but I do that positive shut-off nozzle bothers me a bit.
So, Madam Mayor and Council, let me begin this by saying that the language that you see here on the restriction came directly from the governor's declaration when the executive order was passed during the last drought. So again, so that is the background. So the choice of words here came from standard wording that most agencies are using. Now, in terms of how we enforce these things, we're not going for if someone is not using a positive shut-off nozzle, or if there is a drip versus other type sprayer or other types of modes of irrigation. What we will be looking at is that first and foremost, as Jennifer pointed out, before we do any sort of ticketing or citation, we will start with education, and we will try to reach out to the community just like we did during the last drought, and we will try to give them warnings, and again, first starts with education and then warning, and then try to get them to comply. And if there is a repeat violations and all that, and we see that there is a water running down the sidewalks and into the gutter and all that, then that's where I think what we're trying to stop. Again, what we are also trying to encourage is to have folks be cautious about the use of water. Again, if somebody were to take a hose and put it in a container and water their plants, I don't think staff would be going against that. That's not how we see us implementing these restrictions. So I just wanted to give you that comfort that we are not looking for every word by word and are going to go ahead and go cite people if they don't have positive shut-off nozzle on their hoses. On the other hand, if the council is interested in seeing very detailed language, we can always also do that and bring it back to you. So again, we were talking prior to San Mateo County being in the drought, although the entire state is pretty much in the drought, but there may be weeks and months before we're hearing from the governor that we may have to also take actions to take more prescriptive, more prohibitive actions regarding the dry conditions.
Thank you, Director Martuso. So it sounds like we're going more toward the spirit of the law rather than the letter of the law. So my question before, and I know Councilmember Coulson, you can follow me. Who will actually be the enforcer of this?
So that would be me. So currently I enforce our stormwater ordinance. And so water conservation is kind of similar to stormwater. and that we don't want any illicit discharge into the storm drain. But for this case, it's for the sake of conserving water. And my process for when I do get complaints of, let's say, illegal discharge into the storm drain is that I always take an education first approach. I rarely start with a notice of violation unless it's a repeat offender, because I do keep track of businesses, mobile businesses, for example, that do have a history of doing some kind of dumping. And it's very rarely that I issue citations, and I only do that if I can't get any compliance. And I'm pretty generous with the amount of time that I give them to comply.
Great, thank you, Ms. Lee. Councilmember Coulson, followed by Councilmember Beach.
Thank you. That's very helpful, Ms. Lee. I appreciate it. You know, the number one deterrent for overuse of water is just the cost of water. It's so expensive. And so, you know, I think if we can articulate these values in terms of cost savings for people, you know, so like just the little things like you leave your water running while you're brushing your teeth, you use 3 extra gallons of water or something. To me, that kind of a fun education program is got a lot more efficacy than a bunch of sort of rules that say, do this, don't do that. So hopefully we can continue. I know our CEC has done some great work around this area, and our staff has at the farmers market and things. So I'd love to see that work continued. And then once again, I'm going to get on my recycled water horse here, but we definitely need to start thinking about and looking into how we're going to recycle water. And I think, as all of you know, it's even putting gray water systems in. It's not the easiest thing in the world to do. It's hard. I tried to put one in my house, and I finally gave up and just sold the 750-gallon tank I had to stick under my garden. It was just so impossible to do. So I really hope we'll advance stormwater recapture on property, and we'll advance recycled water at the city level, and gray water systems and the rain barrels and all that kind of stuff. I think that will help people and save money for them and be something that they would really appreciate.
Thank you. Let's remember just to try to keep this with questions, because I still need to open this up to public comment after the reading of the proposed ordinance. Councilmember Beach.
Thank you, Madam Mayor, and I do appreciate Councilmember Coulson's comments and suggestions as far as messaging. My question for staff is, what would be, is there an urgency in getting, this is an ordinance, right? Is there an urgency in getting this done, making the motion tonight, as opposed to bringing it back at our next meeting? If we brought it back at the next meeting with a little bit broader language that provided, you know, that addressed some of the concerns that some colleagues have brought up about the current language. And I appreciate the explanation that a lot of the language came from the governor's declaration. So this is not language we invented. But the reason I asked that question is because even though we wouldn't necessarily, you know, we're looking at the spirit versus the letter of the law, we wouldn't necessarily go chase everybody down if they don't have a, you know, the certain kind of nozzle. It makes me uncomfortable to have laws on the books that aren't really something we're willing to enforce. So if there was a way to broaden some of the language and sort of address some of those concerns, could we bring it back next time? Or is there a reason we really need to get this done tonight? Could you just answer that for us, staff? Thank you.
We certainly can do that, Councilmember Beach. If there's no urgency as I see it, we were trying to line this up before we bring the urban water management plan to you, as that plan requires this ordinance be adopted. So that was the intent. And as the council will be taking summer break, so we were trying to line this up for that purposes. But we can certainly bring this back to you with the changes to the suggestions we heard from council tonight.
Okay, we appreciate that, because there are going to be some community members who are rule followers who will read this stuff and go, oh my goodness, and then it might cause more drama than we necessarily need if we can just broaden the language. Okay, thanks for that input.
So I have a question then to our city attorney, but this is just an introduction, so you could still take what we're saying this evening, incorporate changes, and then it comes back to us for the second reading where we could move forward, correct? Because I think the sooner we do this, the better, considering we are in the drought, rather than extending this through, after summer break.
So Madam Mayor, if the council adopts the first reading of the ordinance tonight, then what would be brought to you in your second reading is the exact same language that you have here. If you were to adopt different language at your second reading, that constitutes a new first reading and you'd have to start the process over again. So my recommendation is if the council would like to see different language than what is currently proposed tonight, that you give that recommendation to, or that direction to staff, and we would bring back a new first reading.
Okay, thank you. I'll make further comments on that after we've gone through public comment. All right, so can we have a motion to introduce, or sorry, first through the city clerk to introduce the proposed ordinance, please?
Sure. An ordinance of the City of Burlingame amending Chapter 15.06 of the Burlingame Municipal Code to establish legal authority to implement the city's water shortage contingency plan and adding Chapter 15.07 to the Burlingame Municipal Code to prohibit wasteful water use practices.
Do we have someone to waive further reading?
Madam Mayor, I make a motion to waive further reading and introduce the ordinance.
Second.
Do we have a sec? Okay. Thank you, Councilmember Coulson. So motion made by Councilmember Beach, seconded by Councilmember Coulson. Can we have a roll call on this, City Clerk?
Councilmember Beach,
Yes.
Councilmember Coulson,
Yes.
Councilmember Brownrigg,
No.
Vice Mayor Ortiz,
Yes.
Mayor O'Brien. You're muted, Mayor O'Brien.
Yep, sorry. Motion passes 4-1. So on that note, I'll open it up to public comment. Is there anyone in the public that would like to speak on this item? Were there any emails, Megan, that came in?
Yes, there was. Let me pull that up. Okay. This email came in from Cheryl Bauer. She says, I'm not available to be at the City Council Zoom meeting tonight. I understand there is a water conservation ordinance being discussed. Will this ordinance discuss the possibility of replacing lawns with drought-resistant plants? Perhaps residents could be incentivized with rebates from the city. Is there the option of promoting a service where plants at the front of homes / businesses are watered with reclaimed water? And then she gives a website for a company that does such business. So I will forward that to you guys.
Great, thank you, Megan. All right, colleagues, any comments? Councilmember Brownrigg. You need to unmute yourself.
Sorry about that. So I began by thanking Ms. Lee for the really good work on the background and also your approach as a regulator in terms of teaching people first and trying to coach people. So I do appreciate that. And I think we can stipulate that all of us want to save water, that we understand the situation that we're in and that water is precious. My concern, and it just hasn't been alleviated by this conversation, is it's a little blend of what both Councilwoman Coulson and Beach have said along the way, which is it's a sort of a theory of government. I don't think we should be passing laws just to shake our finger at people, but we don't really mean it. I also just don't really believe that these particular issues are where we're going to save a lot of water. I think we probably lose a lot of water with people who have broken pipes and don't know it, which, by the way, Director Martuza, am I right in remembering that we have a software system that catches water bills that have gone up for homeowners? I seem to remember that. Am I right about that?
We do have different technologies that we use to detect water leakage, whether it's in the city system or at the resident sites.
Well, leakage, and then in particular to alert a homeowner that all of a sudden their monthly usage is a good bit higher. If we don't do that, I think we should. I guess where I would really like to see us spend our efforts are on programs like Councilwoman Colson mentions, in terms of reclaimed water, in terms of trying to help people catch leaks that they're completely unaware of. That's where we'll save thousands and tens of thousands of gallons of water, and ticketing some poor resident who hasn't put a spring-loaded nozzle on their hose. I just can't feel good about that. So that's why I'm not supporting this ordinance. And thank you for letting me speak.
Councilmember Brownridge, I'd like to, I think you made a very good point about detecting leaks in high water bills. We have a staff dedicated through the water office and our operations team to actually do that work. We currently look at that, the high bills, and we reach out to the customer. We look at what's going on, why their water bills are high. We also look at do investigation, and we do the survey as well. There are a lot of different ways we help them identify what they can do to save the water.
Well, and that's to sort of Councilwoman Colson's point, which is, it's the market signal, it's the bill you get, and then the advice. It's like when our CEC goes into an auto dealer and says, look how much money you can save if you use LED. It's not us banning other light bulbs. Well, we may get to that point too, but at least for the time being, it's been, look how much money you can save. And and it was sort of the nature of the question from the member of the public, like, how can we use incentives to help people do the right thing? It's not like people want their water running down the gutters. I don't know. That's why I'm uncomfortable with this very regulatory approach here. But I do appreciate all the work that you're doing, Director Martusa, to help our citizens really save water. And thank you for that.
Vice Mayor.
Thank you, Madam Mayor. It's not the first time I disagree with my friend, Council Member Brownrigg. It won't be the last. But I think we're just, again, we're taking the language that was set forth by the governor. I don't think we plan to go around writing tickets, but I do think we need the teeth. I do think I have walked by houses where I would have loved to be able to call and say, this is wrong. So they need to be, somebody needs to go talk to them about their the watering in the lawn in the middle of a drought. At some point, we need to just shut it off and live with a dead lawn, or change the lawn to something else. And we need to be encouraged to do that. I think we need this. I think we're going to need it more so going forward. And as one of these days, we're going to look back at this conversation and go, remember when those silly little rules that we were talking about, when right now we're only allowed a certain amount of gallons per day. This is going to become a serious issue. And I think this is a good start, and I am definitely in favor of it.
Councilmember Beach, followed by Councilmember Colson.
Thank you, Madam Mayor. I kind of am a hybrid between my two colleagues, Councilmember Brownrigg and Vice Mayor Ortiz. I'm in favor of the teeth, but my instinct is we should wait another meeting to fine tune the language, so we don't have some law that has some aspects that we just feel could really, aren't accurate. That we could broaden the language a little bit. I do recognize that by delaying this, that means during the summer months, we don't have anything with teeth, but we can still promote the education component about where this is going and what our goals are to try to conserve water. So I'd prefer to get language on the books that we all feel a little bit more comfortable with. That's sort of where I stand. So I would propose that we don't adopt the first reading tonight, but that we wait to bring back our first reading next time. Thanks.
Councilmember Colson.
Thank you. So I am in the Vice Mayor's camp. I believe we should go ahead and pass this. And I'm not really interested in going back and noodling around with all the different options here, because I think our staff is very smart and wise, and they're going to use discretion. Not everybody comes to a complete stop at a stop sign every day in Burlingame at every single stop sign. And we don't give tickets out for that. we use common sense and we use judgment, and, we'll have a set of rules here. We'll have warnings and enforcement, but for the egregious person who does continue to, have gallons and gallons of water running off over this summer, I think we can't afford to wait, because we're not coming back to the middle of August. It puts us into September. And I'd like to get this enacted and ready to go for the peak of summer. And I don't think there's anything here that's, it serves really, if anything, as a reminder to people of all these little things that you can do to, comply with water conservation. So I actually would be fine to go ahead and do this, because I'm not sure what language we would put in this. It's all kind of gray as it is, that would, clarify for people in a way that would give our staff like black and white directive to things. I just don't think we need to be that specific. I think they're smart and we'll figure it out. So I'll support it as it is.
Thank you, Councilmember Coulson. I would have to agree with that. I mean, I do agree with Councilmember Brownrigg. Some of this is a little too regulatory, but I feel a little more comfortable after hearing Director Martusa and Ms. Lee talk about they're not going to be pouncing on people with tickets and citations, and this is, more of an educational tool, and that if there are egregious situations, then okay, you take care of it with that. So, and especially as Councilmember Coulson said, is we're going through the summer months where, it's dry, it's hot. This is the time people are using their water. If we're waiting till, September, we've kind of wasted a few important months for this to be implemented. So I am going to, support this, hoping, and I'm sure will be utilized, common sense through this process. And I think something should be put in the, I'm not sure when the next water bill goes out, that, an educational piece that this has been approved. This is these criteria are listed so that people know about it, and also be put on our website and sent out in our e-news. Okay, so on that note, if anyone has any other comments and questions.
Sorry, I just noticed that there was a minor typo. I guess this is a question for City Attorney. Can I edit that typo later, or should I just mention it now?
You're muted.
Sorry about that. What's the typo?
For the waterways restriction letter G, the prohibition enumerated in subsection D, not F, is the typo.
Thank you. So, Madam Mayor, what I would recommend is that if the council were to adopt the first reading of the ordinance, it would adopt it with that typo corrected.
Thank you. All right. So do we have, we'll go forward now with the motion. Is there someone that would like to make the motion to adopt the ordinance and have it come back for adopt, or sorry.
Move to bring back the
with the
ordinance.
proposed ordinance, correct.
I'll second.
So motion made by Vice Mayor Ortiz, seconded by Councilmember Coulson, and that is with the change that was just mentioned by Ms. Lee with the typo there. Are makers okay with that? Okay.
Yeah.
On that note, City Clerk.
Councilmember Beach?
Okay.
No.
Councilmember Coulson?
Yes.
Councilmember Brownrigg?
No.
Vice Mayor Ortiz?
Yes.
Mayor O'Brien?
Yes. So motion passes 3-2. So then the City Clerk will be bringing this ordinance back for adoption at our next council meeting. All right, item 9C, public hearing and adoption of resolutions adopting the fiscal year 2021-22 operating and capital budgets, and authorizing the finance director to assign uses of fund balance amounts. And 2, approving the gun appropriation limit, and also approving a contribution to the city's pension benefit trust account with PARS.
That's perfect. Thank you. You can sort of consider this the second reading of the budget. We brought to you an initial budget in May, and there haven't been very many changes. So with the year fast approaching, this is where we take the annual opportunity to review the budget in full and look at next year's forecast and spending plan. Adoption of the budget follows a few formalities that you are familiar with, such as reporting on the GAN limit, providing a GASB 54 fund balance discussion, and of course, the budget resolution itself. There's also a resolution for the amounts to be set aside next year for the city's contribution to its 115 trust account to fund pension obligations. And there's really, since there's not a whole lot new here for council, my comments will be pretty brief. Anything that has been updated since the budget study session last month, we highlighted in the staff report, and we'll talk about those changes here. But again, there aren't a lot of those. So on this next slide, I just have, as usual, the table of contents, starting with the city manager's transmittal letter, so that readers can get a real good understanding of Burlingame, its priorities, and the environment that we are operating in. It also contains a budget overview and key budgetary considerations. General information includes how the city is organized by critical service areas, and the org chart identifies the city council and the city's executive team. Then there's the understanding the budget section, how the funds are organized, charts and graphs, lots, and then the largest piece, departmental budgets, narratives, and statistics. That's followed by the 5-year CIP, which provides the basis for 14.1 million of capital funding in 2021-22 and capital projects planned for the next 5 years. And then at the very back, there's a listing of the community funding awards as they were approved on June 7th. Finance is preparing the checks to those community organizations to go out the door the first week of July if this budget is approved. And thanks to Andrew Kwaka for administering the entire application and grant process this year. This year's budget tells the story, thank you, of operating revenues that were badly impaired by the pandemic and the varying degrees of anticipated recovery in each of the city's major revenue sources. The budget does call for spending to exceed revenues by nearly 1.7 million, which will show up as a draw on the city's general fund balance, in addition to the 1.85 million contribution to the city's 115 pension trust. So yes, a continued reliance on reserves and our capital investment reserve, 21.2 million is for the first time totally earmarked for the 2 large projects coming down the pike that council has been planning for and trying to fund as much as possible. Both the Broadway grade separation project and the El Camino Real utilities undergrounding project are now within reach, just a couple of years away from when that funding will be needed. And I know that council hates to think they are working within the limitations of the short term, but such a focus is necessary when we're dealing with a significant revenue reduction that won't be completely resolved in the next 12 months. So on the next slide, I have just to remind everybody, we're not completely abandoning all of the city's long-term strategies. The challenges for the general fund remain the same to cover all the bases while the city's revenues recover. We need to provide high quality municipal services in an efficient manner. Last year, we were able to preserve all full part-time staffing, which helps maintain that operational infrastructure that has been key to providing those qualities, that quality of city services in the past, and to the extent possible through the pandemic. We want to fund our long-term legally obligated liabilities, including debt service, retiree medical benefits, and pensions. We strive to provide a basic infrastructure needs for basic infrastructure needs, although some discretionary projects will have to be delayed. And the project supports the continued efforts surrounding the city's longer-term priority initiatives, policies, and strategies. We do want to keep those going. On the next slide, we have how we address those challenges in the 21-22 budget. We established a reasonable revenue forecast for TOT, first of all. While other general fund revenues and even the general economy might be coming back really strong, we know that Burlingame's hotel faced significant challenges due to the loss of international and business travel. No one anticipates that to bounce back quickly. So we are still in the conservative mode of reduced capital funding and drawing on reserves. These are one-time strategies that we just happen to be using for a second year in a row. They're considered one-time because, of course, they're not very sustainable. But if we look forward a few years, we think these strategies will get us through what we believe is a short-term revenue reduction so that we don't have to take on more drastic measures that would harm our operational infrastructure that I talked about, that foundation, or significantly impede our progress on our longer term goals. In fact, the budget continues the strategy of setting aside funds to pay for accrued pension and retiree medical liabilities to the extent possible. On the next slide, we continue with some highlights. Revenues are beginning to recover. It's just at varying rates. General fund revenues are up to 12.1% from the revised budget, but that's only 9% higher than the adjusted budget. It was mid-year before we recognized in the budget that the pandemic would bring down the TOT revenues by nearly 75%. TOT being the city's highest general fund revenue source, the reduction was severe, to say the least. Actual general fund revenues in 2018-19 were $84.5 million. The total projected for 21-22 is less than $67.1 million. So we really have quite a way to recover. Operating expenditures for the general fund are up 2.4% or $1.5 million. We made one adjustment to general fund expenditures since the May budget study session, and we'll talk about that. So the general fund balance at the end of the year is projected to be $1.7 million, again, less than whatever we start with on July 1st. And we will be restricting an additional $1.85 million, sending it off to the city's 115 pension trust fund with PARS. The balance in that fund was $18.2 million as of May 31st. So we are setting aside the amount according to our plan to that pension trust fund for when the pension requirements get into the nosebleed section, which they're very close right now. On the next slide, I have the general fund revenues. It's also on page 3 of the staff report. You see the 12.1% increase in revenues that's forecasted. Some of our major revenues are going to be slower to recover than others. You can see from the actuals of fiscal year 2019-20 that revenues will be about $5 million short of that. And those revenues were already down $12.4 million from the prior year proposed budget. We just need to accept the fact that some of our major revenues are going to be slower recovering and will not recover in totally in fiscal year 21-22. So let's look briefly at our top 3 revenue sources. We'll just run through them. First, TOT. Thanks, Megan. Usually we start with property taxes, but we'll just go straight to our hardest hit revenue, TOT, which went from nearly 29.4 million 2 years ago to a projected 7.5 million in the current fiscal year. And I should probably say now that that's probably an overly optimistic projection for this year. May and June would have to be up quite significantly, over $1 million a month each month. The good news is that TOT revenues in April that's shown here were higher than the month in 2020, in April 2020. That's the first time that's happened since December 2019. But again, it's a challenge we'll be keeping an eye on, particularly, as I mentioned before, as business travel picks up and restrictions on international travel are lifted. We haven't changed our projection of 13.5 million that we presented in the initial budget in May. On the next slide, I talk about sales taxes. Our projections for May have not changed at all. As you know, we're heavily reliant on data from HDL, our sales tax consultant, in formulating forecasts by sector. The reduction in this revenue source, as you may recall, wasn't as bad as we had thought it might be. We reported that taxable sales for the second quarter of the fiscal year, which would be October through December of 2020, was down 14.2%. But when you look at the calendar year 2019, all pre-pandemic, with calendar year 2020, which was largely in the pandemic, Burlingame experienced an 18.5% or $2.8 million drop in revenue. Over 40% of that decline was from the industry group, restaurants and hotels, a very broad group, but very much a part of our sales tax base. Even though we don't have a full analysis of the first quarter of this year, we do know that sales tax receipts were down 2.1% in the first quarter of 2021 compared to the first quarter of 2020, which you recall had a devastating third month. So in large part, the same industries were hurting, although the auto and transportation sector did come up 9.7%. In that first quarter of 2021. So that's good news. The state and county pools, which receive sales and use tax from online sale, somewhat offset some of the losses, as we talked about in the mid-year report and again in the May budget study session. The next slide shows a chart of why it's so important to be able to see sales tax revenues by sector. You can quickly tell where the revenue losses are. This is also a calendar year comparison chart. Total revenues from local sales tax, not including Measure I, were 15.2 million in calendar year 2019 and 12.4 million in 2020. So again, that's a $2.8 million drop. The drop in Measure I year over year was approximately 400,000. So it's a total $3.2 million reduction in general fund revenues for the calendar year. Just another way to look at that. For property taxes on the next slide, our revenues have held up throughout the pandemic as property values in the area have continued to rise. Here's where we made one revenue change from the initial May budget. Based on the latest information from the county assessor's roll tracker. The tracker today shows assessed roll growth as of January 1st, 2021, and that's the basis for fiscal year 2021-22 tax revenues. The growth was 5.13%. That is better than it looked back in April when the assessor's office was loading adjustments to the roll. However, because the uncertainty in receiving our full allocation of property tax in lieu of vehicle license fees, property taxes as a whole are anticipated to be only 1.3%. Normally, we would be able to budget 4.3 million for this in lieu revenue, but because of recent shortfalls in the VLF fund at the county, we only included 2.4 million for this revenue line item. We really don't know what the VLF shortfall will be countywide this year. So I believe that's slightly less than we had in property tax in lieu of vehicle license fees this year, because the county anticipates an even larger shortfall next year. So that's why our property taxes that are so strong and held up so well will only grow 1.3% in the upcoming fiscal year, perhaps. On the next slide, we show the post-pandemic revenue pie chart for the city. Actual TOT was 36.3%, so more than a third of the total general fund revenues in fiscal year 2018-19. So it really represents quite a shift. And on the next slide, we have expenditure highlights. There's just a few. General fund expenditures are up compared to the current year's revised budget by 2.4%. Increases in overall personnel expenditures were 3.2%. That's about 1.1 million higher than in fiscal year 2021. 1.5% in salaries and wages, and 5.8% for benefits. So those are those pension costs rising, and other operating costs increased only slightly. On the next slide, we show appropriations by type. You can see the entire $63.8 million expenditure budget by category. Of the $756,000, which is the change from the prior year in benefit costs, 647, almost 648,000 of that is the increase in pension, the employer's share required by CalPERS. There was no increase in FTE. So I'll note here that we did make an adjustment to operating costs from the initial budget presented in May. We do use the time between May and this meeting to make sure that budgets will be sufficient for all the departments. Parks Division staff, who had just put out an RFP in early May for the annual tree contract, noted that the contractual services budget would probably not be adequate. Costs in this area had risen significantly over recent years, and the annual scope of the work was expanded to provide some additional tasks that they thought could be handled more efficiently through the annual contract. So $200,000 was added to the budget for the estimated higher cost of the annual contract. So instead of staying flat, operating costs went up an additional 1%. So that's the only change in appropriations from the initial budget presented in May. The next slide shows appropriations by program. These changes are compared to the revised 2021 fiscal year budget. So in large part, those areas with the greatest decreased demands in the current fiscal year show the largest increases for fiscal year 21-22, except for the Aquatic Center. In that case, the decreased expenditures are largely offset by decreased pass-through expenditures. And on the next slide, we have a general fund summary putting it all together. This is where the total change decrease in fund balance of 1.7 million is projected for next fiscal year. Revenues of 67.1 million, departmental expenditures of 63.8 million, transfer for debt service of 3.6 million, less than 3.2 million in transfers out to capital projects, offset by transfers in from other funds of nearly 1.8 million. Bippity boppity boo, you get 1.7 million deficit. And on the next slide, the general fund balance, you see the 1.7 million deficit and how that impacts the fund balance. Much the same as presented in May, because the changes in revenues offset the change in expenditure. And on the next slide, we show how changes in fund balance affect the city's reserves. The total change in general fund is expected to be 1.7 million, but what we've always wanted to keep an eye on is the unassigned fund balance. That is the most discretionary funds the city has. That unassigned fund balance will drop below 2 million, which doesn't allow for a lot of flexibility, especially as we anticipate a couple of years of deficit as we try to catch up on general fund transfers for capital projects. So this budget is the second year where there is no discretionary spending and certainly no contributions to the capital investment reserve. That is only done in years of surplus. Again, the capital investment reserve will end the year with 21.2 million, but it is totally earmarked for those two large projects. And the next slide, speaking of the capital improvement program, it's included in the budget book as presented in May. It's a program greatly reduced as far as general fund contribution is concerned. Again, it's a one-time strategy, but it's been used to ease the burden on the general fund. The general fund contribution in 2021 was reduced 6 million from the year prior. So it is significant. We're getting close here. This, the next slide should read proposed budget. It has been updated. This slide has been updated from what was presented in May. We do look at the budget for all funds. We see no surprises, or we would let you know about them. We're working on setting appropriate rates for the city's enterprise funds, but we don't see anything of concern to the fiscal status or the sustainability of any fund. The total budget for the upcoming fiscal year is approximately 118 million. And now the fun part. This next slide talks about the GAN appropriation limit. As explained in the staff report, the GAN limit is a required exercise. The calculation is, I don't believe, very relevant, but it is required. It takes a separate resolution. The calculation even needs to be audited every year. It was enacted into law. It was intended to limit the growth of governmental budgets. It is adjusted annually for changes in the cost of living and population. But in general, that last bullet, the city can appropriate the proceeds of taxes as long as those appropriations do not exceed the limit. That calculation for fiscal year 2021-22 is included in the budget document. It calculates the GAN's limit, Burlingame's GAN limit at over 91 million, far exceeding the proposed expenditures that are subject to the limit. So we're fine there. And that's it. Maybe the new finance director can give a more robust discussion of the GAN limit if they're into that. So on the next slide, once all your questions are answered, here's what it takes to get a budget adopted. We need to have a public hearing, and then attached to the staff report are resolutions adopting the budget and approving the GAN limit. The final resolution is to approve the 2021 contribution to the city's external pension fund. And once all that is done, we'll post the city's adopted budget to the city's webpage, along with the 2-page budget in brief. Thank you, Karen Wong, for pulling those budget documents together. And that was after making sure every number in the 2021-22 budget ticks and ties as intended. She's awesome. So I'm ready for questions.
Thank you, Director Augustine. Are there any questions? Councilmember Coulson.
Director Augustine, I just have a quick question regarding the rating agencies. Is it my understanding that our rating was improved during this time, or stayed the same?
It stayed the same. We did get a new rating for our storm drain bond issuance, our 2021 storm drain bond issuance, our AA+. So, and that's very good for storm drain bonds, yes.
So AA+, and then our even through all of this financial pressure and everything, we were able to maintain our municipal rating.
Yes.
Very happy about that. Thank you. And then we've gone through this at a pretty extensive length, so I don't have a lot of questions about the actual budget. You've been really comprehensive in answering everything. I appreciate putting some money in the 115 account. This is more of a practical. I have to say, I love my big, thick, heavy book to carry it around. I keep it with me constantly. I know we're going online and virtual, but is there any possibility we'll be able to have copies of the budget made and dropped off, hard copies?
Yes, yes, we will. We definitely will. I didn't mean to say that we have no printed copies.
No, I totally get it. I just, I know a lot of people, I think the mayor is like me. I like to look at actual, this kind of stuff. It's helpful for me. I tag my pages. I mark a lot of stuff. I like to go back through and read it and always have it pretty quickly at hand. So I really appreciate this. And hopefully we'll do some sort of summary or something in our e-news to let people know we've adopted a budget and that we're in good fiscal health.
And there's also something that will be in the recreation catalog, spring catalog or summer catalog that is being put out.
And
maybe
is
it's the fall.
Is it pretty fair to say, this is to City Manager Goldman, that we were able to get through this so far without, we have our FTEs. I know we have our casual employees that we had to make some changes and things and furlough people, but our FTEs, were we able to keep pretty much everyone during this time?
Thank you for that question. We did not lay off a single full-time employee. We did lay off our part-timers in the spring of last year, right when it all started. So I think they went out the door right around the beginning of May. And that was because most of them were working in program areas that we weren't offering. We didn't have inside the library services. We weren't able to offer a good lot of our rec programs. And so that's the services those folks were providing to the community. So we did unfortunately have to let most of those folks go. Some we brought back because as we increased services, but not to the extent that we had back in the day. But all of our full-time folks stayed around, which was great. But you'll notice we were, as usual, very cheap when it comes to adding staff. And so we really have kept the brakes on that for this budget year and last budget year.
Thank you. I can really appreciate that. I think almost every other city in this county, or many cities in this county, didn't get to preserve their entire staff and had to make very unfortunate cuts, which is really too bad. So I really appreciate that. I know our staff really appreciates it. And given, you know, the all around comprehensive financial footing that we're on, I just really want to pay my respects to our finance department for making the appropriate capital moves and things. It's great. I can talk more about that, but my basic questions were about the staffing and the bond rating. So thank you.
Thank you, Councilmember Coulson. Anyone else before I open it up to public comment? All right. Is there anyone in the public that would like to make a comment? To our city clerk, any emails?
There are no emails.
Okay, very good. So I'll close the public comment. Colleagues. Vice Mayor.
Thank you, Madam Mayor. I just look at this and how we're getting through this crisis, and I look back at the many times when people have suggested adding staff for this or for that, and we've held back, and we've kept a very conservative approach to our finances. Thanks to staff and the finance department to help us do it. I think that it's great that we can continue to contribute to our pensions and our 121 plan. I think that's going to become real handy in a few years when the spike happens. And so, you know what, I'm really proud of how we're managing this, and it had to do a lot with how we dealt with our finances in the past. And we always, I just remember that city manager reminding us that TOT is very volatile. And again, I think it's very good to see this budget going through with no huge cuts in staff. And anyway, really proud of all of you and what we did. So thank you very much.
Thank you, Vice Mayor. Councilmember Brownrigg.
Thank you, Madam Mayor. I echo Vice Mayor Ortiz's comments. I want to thank our city manager for leading us through this last year. I mean, we are a city that has many, many special attributes, but one of them is the level of services that we provide to citizens. And that's everything from safe streets to beautiful trees to sewers that work and all the rest of it. And by holding on to people, that's our way of saying to the employees who deliver these services that they mean something to us. And so that was your ability to navigate this last crisis. But I'm going to stop flattering you for a minute. And actually what I want to do with my last minute is just thank Director Augustine for your leadership. I know we have you for another meeting, but this is the last budget that we're going to do together. And Ann and I have been here for 8 budgets with you, I think was my count. And I just want to thank you for embracing multi-year forecasting, which we didn't used to do, for presenting all sorts of background materials along the way, for being unflappable. Like if there's one thing I've learned is you don't want a flappable finance person. And it's just, I think, given us all a sense of real professionalism to have somebody of your caliber manning the ship. And as the Vice Mayor says, we can't deliver on our promises to voters if we don't have the budget to do it, and we don't have the vision to see where we're going. And so I just wanted to take a moment. I know we'll do it next week or next meeting, I'm sure, but I just wanted, because we're here in the budget, to thank you personally for all of that hard work and the department that you've created. So thank you.
Thank you. We do have a phenomenal finance staff.
Thank you, Councilmember Brownrigg. Councilmember Coulson.
Well, just ditto. It's been a real pleasure working with you, Director Augustine. In particular, I want to call out and thank you for your work around the pensions and embracing that when we brought it up a number of years ago and exploring the 115 account. I think that it helps us to smooth and manage our budget, as well as we can look our employees in the eye and say, we are putting the money aside that you need to make sure that you can retire and you will have a safe, and you can be assured that you're going to have the financial promises are going to be paid that we as a city have guaranteed and committed to you. And that's a huge, big deal. And we're doing it in a way that doesn't bankrupt our city. We don't cannibalize our city services in order to meet the promises that we have made. So that work in particular, hats off, and the willingness to explore all the options, I just think was, I really appreciated it. And I think we're adopting a budget that, really continues to deliver the high level of services that Burlingamers are expecting and used to, especially during COVID. In fact, I would say that given our CARES program and our other programs, we actually delivered hopefully services above expectation. And it does it in a way that appreciates our staff and makes people, I hope, believe that coming to work at Burlingame is a place where they're valued and their work is appreciated, which it very much is, not only by the council, but by every single resident in this town. So thank you for putting together such a holistically balanced and forward-looking budget.
Thank you. You bet.
If there aren't any other comments, I will ditto what everyone has said. Director Augustine, you've been phenomenal. We've been so lucky to have you for so many years, and I've had the pleasure of working with you for a long time as council member Brownrigg. And, you know, you've always been very good in directing us and giving us options to make these tough decisions. And we've made some tough decisions in the past. And I don't think we'd be in the position we are now, considering we went through COVID without those decisions from the past. So thank you again. And we'll have another meeting to give you some more kudos, but you will definitely be missed.
Oh, thank you. You know, I never had to do the hard part of convincing the council that a long-term approach is what is necessary and best. I didn't have to do that. I walked in to a council that was very forward-thinking and had set aside funds for retiree medical. They weren't quite sure what process that was going to take, but they had set aside some reserve funds with that in mind. And so that part was done, and the rest was a lot easier.
I bet you say that to all the councils.
Yeah, all the councils.
All right, on that note, we need a motion this evening. So to our city attorney, can we have a motion that encompasses all three elements? Or does it have to be each resolution taken separately?
I would prefer, the record is cleaner if you do if you take up each motion separately.
Okay, very good. All right, colleagues, who would like to start?
I'll make a motion to approve the GAN limit. Was that the first one?
That will be the second one.
Oh, sorry.
Well, I'll second that one.
All right, motion made by Councilmember Brownrigg, seconded by Mayor Ortiz to approve the GAN appropriations limit. Director, or sorry, City Clerk.
Councilmember Beach.
Brief quick comment on the motion because I didn't speak before. Everybody on Team Burlingame, way to be fiscally responsible. Huge thanks, Director Augustine. I vote yes to approve the GAN limit. Thank you.
Councilmember Coulson.
Yes.
Councilmember Brownrigg.
Yes.
Vice Mayor Ortiz.
Yes.
Mayor O'Brien.
Yes, motion passes 5-0. Okay, so now we need a motion to adopt the resolution for the fiscal year 21-22 operating capital budgets.
So moved.
Okay.
Second.
Motion made by Vice Mayor Ortiz, seconded by Councilmember Beach.
Councilmember Beach.
Yes.
Councilmember Coulson.
Yes.
Councilmember Brownrigg.
Yes.
Vice Mayor Ortiz.
Yes.
Mayor O'Brien.
Yes, motion passes 5-0. And then the last resolution is approving the contribution to our city's pension benefit trust account.
Of course I have to make that motion. Are you kidding me? I make the motion, a motion to approve the resolution of City Council approving a contribution to the PARS, a public agency post-employee pension benefit trust administered by the Public Agency Retirement Services PARS.
Why don't we let the mayor second?
I'll second it then. Motion made by Councilmember Coulson, Mayor O'Brien seconding it. City Clerk?
Councilmember Beach.
Yes.
Councilmember Coulson.
Yes.
Councilmember Brownrigg.
Yes.
Vice Mayor Ortiz.
Yes.
Mayor O'Brien.
Yes, motion passes 5-0. Very good. Item 10A, consideration of an appointment to the Storm Drain Citizens Oversight Committee. We have staff report from our city manager.
Actually, this one is run by the Public Works Department, so I'm going to
sorry.
hand it over to Syed. No problem.
Director
Next one.
Medusa.
Well, I was just secretly hoping that Lisa would do the report. Madam Mayor and Council, again, this staff recommends that Council make an appointment to fill one of two vacancies for the Storm Drain Measure Citizens Oversight Committee or take other action as noted in the staff report. The vacancies are due to the resignation of a former mayor, Councilmember Rosalie O'Mahony, and also term expiration for Kevin Osborne. The vacancies were publicized as noted in the staff report. And unfortunately, prior to the interviews, we actually had 2 applicants for the positions. And unfortunately, prior to the interview, one of the applicants withdrew their application. As a result, the council interviewed Mr. Michael Barber on June 9th. Council is requested to take action regarding the appointment. And if council appoints Mr. Barber, the term will be for 4 years, ending on June 21st, 2025. I'll be happy to take it.
Thank you, Director Martusa. So through the city clerk, since we have 1 applicant, how do we proceed with this? Do you still have to do ballot or can't?
Yes.
Okay.
I ask that you still text me your vote and I will call out your vote.
All right, so we're gonna do that now?
But we should open it up for public comment.
Oh, that's right. Okay, sorry about that. Public comments. I am opening it up. Is there anyone that would like to comment on this item number? Okay, if not, I'm gonna close the public comment. Did we get any emails, Megan?
We did not.
Okay, so now we can go forward with the texting.
Clarification, are we chatting it or are we emailing it?
We're texting, aren't we?
Okay, texting it. Very well, thank you.
That's what the youth do, Vice Mayor Ortiz.
Yeah, my thumbs are not shaped that way.
If you're doing the youth, you'd be TikToking it over.
Oh, okay. So Councilmember Beach, Barber, Councilmember Colson, Barber, Councilmember Brownrigg, Barber, that confused me, thank you. Vice Mayor Ortiz, Barber, and Mayor O'Brien, Barber.
All right, so Michael Barber will be appointed to the Storm Drain Citizens Oversight Committee. Next, we have the consideration of the 1 appointment to the Library Board of Trustees.
This one is me. So you do have 1 vacancy on the library board. Randy Murray, who served for quite some time, elected not to reapply. So as we normally do, we publicize the vacancy, sent notification letters out to past applicants, and you received 1 application as of the deadline, and that was from Chris Cannon, and you interviewed her a couple of weeks ago. I understand she served on the library board way back when, I think in the 80s, so she's back for more. And if you could open up for public comment and then text your choices over to Megan. And this is a 3-year term ending June 30th, 2024. Thank you.
Thank you to our city manager. I'm going to open up to public comment. Anyone in the public that would like to make any comments? Doesn't look like it, so I'm going to close public comment. Megan, any written emails?
No, there are none.
Very good. So then on that note, to my colleagues, please text our city clerk on who you would like appointed.
Okay. Councilmember Beach, Cannon, Councilmember Colson, Cannon, Councilmember Brownrigg, Cannon, Vice Mayor Ortiz, Cannon, and Mayor O'Brien, Cannon.
Very good. So welcome back, Chris Cannon. All right. So on to council committee and activity reports. Is there anything anyone would like to add? If not,
I'm going to, may I please, Madam Mayor, just really quick? I just wanted to let everybody know that we are really working hard on our capital campaign for the community center. And so if you know of anybody who's interested, please let us know, because we are probably pretty close to over halfway over our goal. So yeah, we're doing really well. Thank you, Deb Leone, Emily Matthews, and the team that's working on that.
Very good. Thank you, Councilmember Colson. Future agenda items. Councilmember Brownrigg.
Thank you, Madam Mayor. There have been moments of levity, but this is not one. So it's just briefly, but importantly, I think, it has to do with the Bayside changes that we've been considering. And it's come to my attention, and I think probably others, but that the development community heard our conversation as being very, very encouraged by our desire to change zoning to 3 FAR and allow life sciences, but did not hear us talk about any impact fees or other fees. And I think may have misunderstood that conversation to be the end of our conversation. And I don't believe that's necessarily what we meant. And therefore, Madam Mayor, I'd like to suggest that we have a conversation about what additional fees might be appropriate in light of the fact that we've done two things. We've significantly appreciated the value of the land, and we've also identified, in part through the work of the flood agency, whose initials I never remember, but the additional work we're going to need to do to buttress our Bayside lands against sea level rise. So with that in mind, I'd like to suggest that we have a conversation about what additional impact fees might be appropriate and so forth, and kind of let the market know that we're not done with this conversation. Thank you. I don't know if there's a second for that, but I think it's kind of important to send the signal to the market.
Well, I actually have a clarification, so I don't disagree with what you said, Councilmember Brownrigg. That was not the end of the discussion that we had. But for some reason, did we not have Planning Commission looking into some of this in regards to the amenities that could be potentially offered to the community? Or am I mistaken with that?
Kevin, can you weigh in on that? There he is.
Yep, sure. Yeah, so the Planning Commission has looked at the community benefits as part of the zoning ordinance update. That may be a little different.
Oops, we've lost him.
He's got Donna's service.
My service is good now.
No, I'm sorry, I meant your old service.
So what I think he was saying is that what Planning Commission is doing is a little bit different than what Councilmember Brownrigg is suggesting.
Okay, so then I say,
are you back, Kevin?
Yep, I'm back. I had to go back downstairs. So yeah, so the Planning Commission had discussed the community benefits as part of the zoning ordinance update. The council will also be having that discussion this fall as the council looks at the zoning ordinance update. That is a little different than impact fees, which are related more to things that a project offers as part of a larger floor area or building height, whereas public impact fees or fees such as sea level rise would be
okay, Director, I think we get the gist of it. So
we've lost him again.
We'll just, yeah, I would be fine in bringing that back at a later date to discuss.
As soon as Kevin has good wireless, then we'll let him know.
Okay, very good. Councilmember Beach.
Oh, thank you, Madam Mayor. I didn't know if you were seconding. That's certainly the issue of impact fees is something I know I brought up at the Joint Planning Commission meeting and the other meeting in February. So I would certainly support exploring that further. Thank you.
All right. Anything else for future agenda items? If not, acknowledgements. Are there any acknowledgements for this evening? Okay. Then I guess we are at adjournment. I just want to remind everyone that our next council meeting will be on the 6th of July at 7 o'clock.
Good night, all. Thank you.
Have a great evening.